Here, for the field state of Michigan town session. Honorable Stephen L. Burrell, Honorable Brock A. Schwartzel, presiding the Honorable Thomas C. Cameron. All persons having business herein drawn here to the attention and they shall be heard. God save the United States, the state of Michigan, and this honorable.
Good morning, everyone. On behalf of Judges Borello and Schwartzel, I'd like to welcome you all to our second day of hearing cases here in Detroit. Just a few housekeeping matters. I'd note that we do have a number of cases involving minor children. If your case involves any minor children, I'd ask that you identify them by name or some other reference rather than by their names to protect their anonymity. Also, we have a number of cases with multiple parties, which possibly with multiple attorneys. Please identify how you're going to be splitting up your time, if that's the case for you. And then finally, if you have a client who is here today, if you could please note that before you begin your oral argument. So with that, why don't we call the first case, People of the State of Michigan versus Batzer. That's item number 369901.
Good morning, judges. My name is Robert Tomac. I represent the appellant Austin Martin Batzer. This is Mr. Simon's brief, his excellent brief. On behalf of the appellant, 4 issues are raised. These are pretty much explained in the brief. I want to talk about the issue having to do, issue number 2 having to do with the testimony of the same nurse. I would think that this kind of a situation would raise problems in other cases of this nature. An objection was made to the testimony of the nurse as she was testifying and basically repeating the statements of the victim. And clearly these were all medical related, I submit. I mean, when she talks about the gun, the handsaw, and then she talks about being picked up at a gas station and being trafficked and so forth. I would submit that was a proper objection, and the court should have not allowed that part of the testimony. And so, in that regard, as to issue 2, I would submit or I would just like to bring that, especially to the court's attention. The other issues, judges, are pretty much explained in the brief, and I would rely on the written brief for those.
All right. I don't see any questions. Thank you very much. You've got plenty of time for rebuttal.
Good morning, and may it please the court. Joshua Miller from the Oakland County Prosecutor's Office Appellate Division on behalf of the people who are the plaintiff appellee in this case.
Hey, who's running the show over there now?
We have Mr. Brandon Barlog is our chief of appeals.
I know. Was he an appellate lawyer?
He's not.
That's why I don't know who that he is.
Yes, he came to us from the Circuit Court Division. So you might have seen his name in a transcript before, but
big mistake. Big mistake. You tell your boss, big mistake. Of course, you can't replace Miss Day. She was
and we still
one
have
of
her
my
part-time.
favorites.
We still have her part-time, so
yeah, that's what she said.
yes. As long as she can put up with us in her retirement. So
you guys are by and away the best appellate division in the entire state.
well, thank you. I appreciate that on behalf of my colleagues, and I will be sure to pass
There's
that
not
on.
even a close second.
Thank you, Judge. I do appreciate that. I don't really have any argument to add beyond what's in the briefs. We're asking the court to affirm the convictions. I did want to note, the defendant filed a standard 4 brief, and there was one thing I wanted to address from that. He continually refers to Miss Allen as an agent of Homeland Security. She is a social worker and forensic interviewer at Care House. So I don't know where he's getting the Homeland Security thing from, but her interview was referenced in during the testimony of the victim, both during direct and cross-examination. So I just wanted to point that out for the court so that there's no confusion as to who Miss Allen actually is. But other than that, the issues that were raised first by Mr. Simon, who was first appointed counsel, as well as by Mr. Tomac, I rest on the brief unless the court has any specific questions for me.
No. No, thank you very much.
Thank you.
Good to see you as always.
Likewise, Judge.
All right, thank you very much.
Thank you both.
Yeah, thank you both for being here today. That matter is submitted. Turning now to the next case, item number 16, Attitude Wellness LLC versus City of Royal Oak, 371309.
Morning, Your Honors. May it please the court, Kevin Blair on behalf of Appellant Attitude Wellness that does business as Loom. I'll be very brief this morning, primarily relying on our briefs.
Well, did you bring us any samples?
Not today, Your Honor.
I'll have you know, I have been informed and I believe it's true. I have a bud named after me.
Oh, I didn't know.
Wow, you should do your research. I didn't know it either, but thank God my parents were not around to see it.
It probably causes some pretty significant mental problems.
I am loved.
Yeah.
Anyway, I digress. So here we're dealing with, in my opinion, an obvious OMA violation at a minimum. Why, but how do we throw the so-called baby out with the bathwater here? How is it that your client gets another shot at being a licensed facility in the city?
You mean with regard to the Open Meeting Act issue in particular, or more generally?
You can go small, you can go big. I'm
Well, I would
throwing
say.
it wide open to you.
Okay, I'll start with the narrower question as to Open Meeting Act in particular. The different panel of this court has remanded for the circuit court to consider certain factors that were not considered on the front end in terms of how it affected the public's rights, et cetera. And that was delayed by the city's appeal to the Supreme Court. But that would be as to if the circuit court finds that this did affect public rights, as we believe it did, then the remedies under the Open Meeting Act could include invalidating those decisions and redoing the process in a way that does comply with Open Meeting Act
So
requirements.
exclusive cap was argued, if I remember correctly, on a MCOA a few weeks ago.
Yes, yes, sure.
Are you aware of any decision that's come out from the Supreme Court on that issue or on that case?
I am not aware of one.
Okay. The one question I had with regard to the OMA issue, I assume that the city manager, like in almost every other place I'm aware of, was not a member of the city council.
Correct.
Okay,
I believe that's correct.
because in the Regent's case, the Supreme Court back then thought it was pretty important to highlight the fact that the regent, the individual regent, was also a member of these little subcommittees that were then held to be subject to the OMA. But here, the city council and the city manager are completely separate.
They are separate, Your Honor, but
I don't know that that matters, and we'll see if the Supreme Court thinks it matters when they take up. Hopefully, they do something with exclusive cap, but I just wanted to make sure I understood the facts.
Yes, I was just going to add, Your Honor, that in Pine Brook, Warren, the court did address that it can be a public body either on its own right or delegating from the
In
public body.
Pine Brook, again, we had a committee, if I remember right, it was a review committee underneath the city council. Here we have the one person, and I just find it odd that we're allowing one person to be a committee. I mean, every time he has a thought, does he have to have an open meeting?
Well, Your Honor, I respectfully disagree. The ordinance calls for the city to make the determination. And then the city manager was to rank them with and the people of his choosing. And we argue that that did constitute a de facto review committee It just
Oh.
wasn't named by the commission necessarily.
If I remember right, an exclusive cap, they kind of went, if I remember right, they went both ways. At the beginning of the paragraph or two paragraphs, you could read it as, well, it was the city manager plus a couple other people that made up the body. And then at the end of that analysis, it was at either end of the paragraph or the end of the second paragraph, the language of the opinion made it clear it was just the city manager who was considered a committee under the OMA. And then there was that footnote that made it clear that the members of the other people who the city manager sought out to help were not members of a committee. And so I think that opinion's a little confusing on that issue, but I get your point.
Yeah, and I would agree on, you know, it's not super clear on that. But I would reiterate that, the city manager did testify repeatedly, that it was a collective decision. And to the extent that there's concern about the, you know, that an individual can't have an open meeting when they're having thoughts amongst themselves. There was, significant testimony that there were decisions made during these meetings amongst multiple people talking about issues out loud that were behind closed doors and not, noticed and not available for public participation or even observation.
Okay.
And that may be a good segue into the MERTMA argument. So I believe the Open Meetings Act issue has been decided. You know, the Supreme Court may change that. On the MERTMA aspect, though, Loom's arguments differ from that of Quality Roots and Exclusive, including the Loom's challenge to the local preferences that were one of the mandatory criteria that had to be considered, and that there was unrebutted testimony that it was considered and it was dispositive. There was a post hoc litigation argument that Loom was not excluded based on that. But we submit, and as outlined more in the briefs, there was more than enough evidence for a reasonable fact finder to find that that was pretextual, and that local preference, which multiple courts have found is unconstitutional, did play a factor in the selection of the two least experienced but most politically connected applicants, including one that was 88 feet from a school. And that also ties into Yellowtail. The city puts a lot of emphasis on that case. As we've outlined in the briefs, we believe that that's clearly distinguishable. I was involved in that case as well. And it was by far the most thoughtful, thorough process that we've seen anywhere in Michigan. That was during COVID. They had hours of Zoom testimony where they were going through each factor meticulously. There is language in there suggesting that municipalities have a lot of discretion, but it's necessarily tied to the facts of that case where it was a very thorough, thoughtful process. The court was understandably reluctant to make them start that all over again, especially when the challenger that brought that case was complaining about a number of points that would not have changed the outcome at all anyway. So why make them redo the whole process? No court has considered, much less decided, the issue here with a black box determination behind closed doors, where some of the factors that the local ordinance requires the decision makers to consider include things that would be an unconstitutional preference for locals, and factors that have absolutely nothing to do with assessing the relative suitability.
Your argument about unconstitutional preference for locals, is that your dormant commerce clause?
Yes, Your Honor.
I question whether you can have a dormant commerce clause claim at all in a market that is unlawful. And your dormant commerce clause is under the federal constitution, under the federal government. Everything about this is unlawful. So how do you have a dormant commerce clause claim when the good at issue, marijuana, is outlawed at the federal level?
Your Honor, a number of circuits have taken up that issue. And I believe the First Circuit and the Ninth and perhaps others have found that there is a dormant commerce clause claim despite the illegality under federal law.
I believe the Ninth Circuit went the other way.
You may be right about that. I should not have said that without having more recently looked at that.
But I think you're right about the first.
But, and I would also say that we also asserted claims under the Michigan Constitution, under the Equal Protection Clause, and cited cases that favoring locals over non-locals would violate the Michigan Constitution as well.
Okay, thanks.
Unless the court has any other questions, I'd like to reserve the balance of my time for rebuttal.
You wrote an excellent brief. Thank you.
Thank
It's
you.
very helpful.
All right, thank you.
Good morning, Your Honors. Anne McClory McLaughlin appearing for the City of Royal Oak. I'd like to just start briefly with the Open Meetings Act claim. I argued the mini oral argument on the application to the Supreme Court on March 12th. We do not have a decision yet.
Okay, thank you.
As far as the remaining claims that Attitude Wellness has brought, there's really only one outstanding issue that was not previously addressed by any court, appellate court. Exclusive Capital Partners addressed the content of the ordinance and its compliance with the Michigan Regulation and Taxation of Marijuana Act, and found that the city's criteria in its ordinance were in compliance with, or at least did not violate, the MRTMA, and that the city had discretion to include criteria that do not necessarily directly relate to the sale of marijuana, but that address cities' preferences, values, and goals. And that's been pretty much the position of the appellate courts in Yellowtail, as well as other cases, the Pine Brook case, where it didn't talk about the Open Meetings Act, and Terry Investments versus City of Mount Pleasant. Those all upheld the local preferences or local criteria against facial and as applied attacks by the losing marijuana applicants. With respect to the Dormant Commerce Clause claim, I believe that that's the only one really that the other courts have not addressed. And in this particular case, I agree with Your Honor, Judge Swartzel, with respect to the legality or lack thereof on the federal level, and whether it could be, whether there would be a constitutional claim under the federal constitution. But even aside from that, even assuming that it's a valid claim, we have the question of the plaintiff standing to object to that. You know, the plaintiff has complained about the fact that the winning applicants were allegedly the least experienced and most politically connected. Well, the reason they were the least experienced was because they'd never operated marijuana businesses before. But before 2019, nobody had ever operated a marijuana business in Michigan.
Well, they just didn't do it lawfully.
Well, yeah. Well, I'm excluding the black market.
They didn't come to the city commission and ask for a license.
Right, but
All those RICO conspiracies.
that's right. That's right. But in any event, there's no evidence to suggest that the city's grant of or award of licenses to the two successful applicants was a pretext for some other improper motive. And as for them being politically connected, the alleged political connection is that the two lawyers representing those applicants in the application process were members of the city commission 25 and 20 years ago. So that political connection is pretty remote at best. In any event, not to mention, I do know that even though it's a nonpartisan city commission, that the political leanings of those lawyers is different from the current city commission. So in any event, the plaintiff doesn't have standing to claim that the dormant commerce clause or equal protection clause apply because here they were not adversely affected by that criteria. It's only one of 10 criteria in the ordinance, and it was not a basis for denial of their application. It's only one, and it's not a residency requirement. It's only a factor that the city can consider. And in this case, the plaintiff wasn't adversely affected by it because it took great lengths in its application, which we attached in our appendix, to show that they did have connections to Royal Oak. The principles of Attitude Wellness are also the principles and owners of Bell Tire. And they have 2 locations in Royal Oak. They made sure to point that out. They even took the measures of showing all of the possible connections that they had to Royal Oak, including going back to their attendance at a Royal Oak School District elementary school. So they weren't adversely affected, and they in fact presented that information and presented that those facts to the city. So they met that criteria, and there wasn't any implication anywhere that the city decided otherwise in this case. As far as any other arguments, I'm happy to rely on my brief and happy to address any questions that the court might have.
Oh, I don't see any.
Right.
Thank you.
How's my former classmate, Miss Amsbuehler? I understand she retired.
I told you that, I think, when we argued the
Yeah.
exclusive capital case, right?
Still retired?
Still retired. Yep. I haven't seen her in probably a year.
Wow.
Yeah.
I should have stayed in the law. You guys make a lot more money. We have a little
I don't
less
know.
stress.
I don't know about that.
The problem
Litigation
with,
can be stressful.
yeah, the problem with being a lawyer was clients, right?
Some can be, for sure.
Well, good to see you again, Counselor.
Good
And
to
if you
see
do
you
see
too.
her, please send my best, would you?
I will.
Thank you very
I
much.
did the last time too, because we do keep
She probably went,
connection.
who was that guy?
No, I think she remembers you.
We actually had a case together. I went, gosh, probably 35 years ago now, but I was representing a sheriff and I think she had a county or something. Anyway, we ended up in the 6th Circuit in that one,
Oh, okay.
but it was kind of fun to see her again. So,
Yeah. Yeah, she was a good lawyer.
and then you had an appellate person named Marcy,
Marcia Howe? Oh, no.
no,
Marcy Stepansky.
Stepansky. Is she still with the firm or?
No, she left the firm 2 years ago.
Oh, okay.
Yeah, she's practicing on her own now, I believe.
Oh, okay. She did good work too.
Yeah, she did great work. We were sorry to see her go.
Yeah. Well, thank you.
Thank you.
Can you tell I'm the old judge now? I'm sitting here like E. Thomas Fitzgerald. Hey, how's Harvey been? You know, we used to have a beer together on St. Patrick's Day. Anyway, I apologize.
No worries. I'll take friendly questions like that any day, not incriminating ones about whether I've tried your strain of.
I didn't ask if you tried it. I just, I wouldn't go that just if you, I've never been able to find it though. I will say I'm a little leery to look for it on any of the court computers, so.
I just want to address 2 quick points. One was that the point that nobody had experience. The first stores opened in Thanksgiving time of 2019. These licenses were awarded in early 22. Loom and other applicants in the field had 2 years of history showing that they could comply and faithfully did comply without any violations for that period of time. And to compare them to folks that had 0 experience or very, very little experience and the political connections, I think is a bit of a stretch to say that, you know, Yeah, I wouldn't say that the experience is dispositive, but it is certainly a relevant consideration. And it kind of goes to the underlying point of this was a black box and nobody knows what was actually considered. And the least qualified, most connected folks wound up with a license, including one that was 80 feet from the school. The other point that I wanted to make is that Sister Council emphasized that the local preference was only one of 10 criteria, but does not dispute, nor could she, that the ordinance specifically requires that criteria be considered. The ordinance says that shall be among the considerations.
But what about the fact that your clients actually did have local connections?
I don't think it prevents us from challenging the constitutionality of that local preference, that we tried to put our best foot forward in that regard. And the way that it was phrased, it was unclear actually whether someone who owned a different business that was there would necessarily qualify the applicant entity for those points or not. And again, there was testimony that was considered a deal breaker, a disqualifier without that. And the fact that it wasn't referenced in Loom's denial letter, I think is also certainly not dispositive and not even relevant. The one factor that there were two things mentioned in Loom's letter. One was that there was a limited number of licenses. That's not a reason to deny anything. And the second was that Loom's infrastructure wasn't sufficiently green for the city's liking, which has nothing to do with suitability. And here we have a citizen initiated law that specifically requires one methodology for handing out limited licenses. Respectfully, I think some of the dicta in Yellowtail conflates the time, place, and manner section 6, that as long as it's not unreasonably impracticable and doesn't conflict with MRTMA, that municipalities can regulate the time, place, and manner. But that is separate from the one provision that specifically governs the competitive process that mandates a specific methodology. And here we had a number of well-qualified, proven applicants, one of them being Loom, all applied, and these very lucrative licenses wound up going to the least experienced folks under black box circumstance.
So let me see if I understand your argument. The time, place, and manner would be an appropriate consideration, but not as part of the competitive process for selecting the winners.
Exactly, Your Honor.
So when would the time, manner, and place requirements come in if they don't come in at the beginning where the company is explaining how it would operate, where it would operate? I guess I don't understand your distinction.
It's not a perfect analogy, Your Honor, but I believe that there are some strong parallels to case law interpreting content neutral First Amendment restrictions, right? You can regulate the size of the sign, what hours the sign can be out, et cetera. And those are neutral and apply to everybody, no matter what the sign says, realtor, political, whatever it says, right? And I would say that Section 6 is about regulating the businesses, whether you don't want them out open past 9, or you don't want them in certain parts of town, or any of those things. I think that's all time, place, and manner. But the canon of interpretation that the more specific provision governs, there's a sentence in 9(4) that unambiguously specifies the one thing that matters when you're deciding between competing applications, and that's intended to operate in compliance with MRTMA, right? If you read out in compliance with MRTMA, best suited to operate in the municipality, you could give it to anybody, right? And I know that there are some Court of Appeals decisions that suggest there's a lot of leeway there, and we don't have to overturn those. There is a lot of leeway there, but this is not Yellowtail. This is not carry. This is an instance where the ordinance on its face required the decision maker to consider things.
So
Go ahead.
just for my own,
Yep.
among the criteria then should only be factors dealing with the lawful exercise of the permit or the license in terms of operating within MERPMA. And that's all the criteria that cities should look at or municipalities should look at.
Ideally, yes, I think Yellowtail.
I don't mean to, and I'm not trying to be flip here, but wouldn't every at least viable license, wouldn't they all explain how they're going to operate within MERPMA? I mean, you're going to disqualify a permit right out of the gate if it says, MERPMA, we're not going to really pay attention to it. A suggestion, not the law. I mean, that seems silly to say that's all that the city council can, or the city can look at in terms of selecting among the criteria, those who will do it lawfully. They're all going to say they're going to do it lawfully. So how would a city use that criteria to actually select 2 out of 10?
I have 2 responses to that. One, I would say that it's not that every single criteria necessarily has to be closely tied to suitability to operate in compliance with MERPMA within the municipality. I think Yellowtail, the holding of that necessarily accepts that there might be some non-outcome determinative factors that skew a bit from that, very narrow. But the language in MERPMA is so specific that it's intended to select the applicant best suited to operate in compliance with MERPMA within the municipality, that it's not enough for an applicant to just say, yes, I intend to comply, right? And one of the things we highlighted in our brief is it's not that Royal Oak didn't explain why they believe the 2 license winners were best suited. They didn't explain why, but they didn't even articulate at the time that they believed those 2 were the best suited, right? They designed this process where they gave it to the new city manager, and they even went through the spectacle of passing an ordinance that said the commissioners weren't allowed to communicate with the applicant so that they could, distance themselves. And it's the new city manager that just happened to steer it towards the politically connected folks. That's the issue here, that there was never even a finding that they were the best suited.
Well, I guess you could have some applicants who have what would be considered better safeguards in place to doubly ensure that they follow MERPMA, or triply ensure that they follow MERPMA. So, okay.
And in the heat of there are not as many cases, involving MERPMA today, not nearly as many as there were back then, right? In the heat of the moment back then, I think there was fear that there would be a avalanche of cases, if there was any teeth given to the plain language of this mandate. But the reality is there's not a single case that's been litigated where a municipality affirmatively stated, we believe applicants X and Y are the best suited. And that was challenged just because it was conclusory and fighting about whether that was actually true as a factual matter, right? That case never happened. And I would say that at a bare minimum, that MERPMA language requires that the municipality actually make a determination that they believe certain applicants are best suited, as opposed to a black box where it comes out and says, okay, these are the 2 we want to give the license to. So those are the points I wanted to make. If there aren't any other questions, I appreciate the court's time, and we ask you to please reverse and remand on the Open Meetings Act issue, as well as the MERPMA and constitutional issues. Thank you.
Thank you both. The matter is submitted. Turning now to item number 17, Tobis versus Olive. That's 372461. I believe Mr. Tobis is arguing remotely.
Hello.
Hello, we can hear you. We can't see you.
I also want to tell you I'm not driving. The car's not moving, so I just wanted to point that out.
Okay.
This is a court proceeding, Mr. Tobus. You don't appear to be dressed for a court proceeding, and you're sitting in a vehicle.
I apologize, Your Honor. I have been going through a lot since the last 2 months.
Yeah, well,
all right. Let's do this. Once you argue your case, go ahead.
Thank you. So I'm appealing this emotional distress claim from the Oakland County Circuit Courts because the lower courts claimed that there was no intentional tort or emotional distress and so forth, when that is the farthest thing from the truth. With everything I mentioned in the appellate brief and after the warranty company Olive claimed to pay for the repairs that are not previous issues, which in my case was not a previous issue with the car, but despite this being the fact, Olive continued to be negligent to pay for the repairs, which then resulted in my father, Jonathan Tobes, to step in and pay for the repairs that Olive was supposed to pay for. And because the repairs were not paid by the warranty company like it should, and the repairs were paid by my father, it started to impact my father's life drastically because he started getting behind on all his bills. Olive financially ruined my father's life that he could no longer live on his own. So much he had to move back in with his ex. And so far, with all due respect, the courts, the lower courts, or I don't know, courts in general, have not done a single thing to hold Olive accountable for their negligent, intentional infliction of emotional distress, which in this case would be Olive's negligence to pay for a repair caused my father's life to go down in shambles because it caused my father to have to pay for the repairs, which I tried to get Jonathan Tobes as a witness in the lower courts, but the lower courts approved summary disposition.
Mr. Tobus, just so you know, and I probably should have mentioned this, we're very familiar with the facts. We've read everything. We've read your brief. One of the things that you can tell on people who are arguing remotely, like yourself, I can see your eyes going back and forth, which is telling me you're reading your brief. So I'm going to encourage you to do is just pick the legal issue that you think your case turns on and explain to us what it is you think the trial court did that was error.
Okay, Your Honor. So I believe what the lower courts did not do was, one, they did summary disposition. They the lower courts did not even give me a chance to express all of these concerns that I'm expressing to you today, like my father, which I believe he did try to join the Zoom meeting, but I don't know if they let him in or not. Um, but I wanted to have him as a witness because I wanted the courts to hear my father explain how Olive has impacted his life. But the lower courts did not do that. They did not even let me argue why. They just they just did summary disposition. Just they did not care about me.
So that's number one. Anything else? And what we can do too is you have a thing called rebuttal. We can hear from the attorney on the other side. You can listen to what he has to say, and you can spend what remaining time you have to respond to the arguments you hear. That's another approach you could take.
Okay, Your Honor.
Okay. I'm not trying to push you in a direction. I just wanted to let you know that might be a better use of your time because this way you can hear what the other side says and you can respond to those legal arguments. Okay?
Understood.
Okay.
Thank you.
Hold tight. If you have a mute button, I'd ask you to use it so we don't hear cars.
Good morning. May it please the court, Michael Cook on behalf of defendant Eppley Olive. I believe our brief thoroughly addressed the issues, particularly legal issues, so I don't plan to re-argue or reiterate that. I'm primarily here just in case you have questions.
Thank you, Mr. Cook. I don't have any.
No, I don't.
Okay, thank you very
We're
much.
asking you to affirm. Thank you.
Thank you very much. All right, Mr. Tobis, why don't you take yourself off mute? So the other side didn't have a whole lot to say, but I don't want to cut you off. Is there anything further you'd like us to know?
Yes, Your Honor. So, unless it's something I have not said yet, I just hope that this court finally sees things from my perspective and understands why the court should favor the appellant over the appellee.
All right. All right. We understand your position. We've read your materials. We read the other side, and you'll be hearing from us shortly. We'll issue a written opinion, okay?
Thank you, Your Honor. Thank you.
You're welcome. Have a nice day.
You too.
All right. Number 17 is submitted. And turning now to item number 18, Member Select Insurance Company versus Estate of Connor James Clancy. That's item number 372802.
Good morning, Brian McKenna on behalf of the appellant. It please the court. I did listen. I understand that the court has read the briefs. I will try to just highlight some things that I think are important to address. We're here because this issue before the court is the rescission of a third party bodily injury coverage on a policy that was issued by Member Select. This policy was issued by Member Select in June of 2021. This crash that involved my client's decedent was October 24th of 2021. So there was a significant period of time between the time that the vehicle was added and the date of the crash. At the time that the vehicle was added, there was a recording. That recording is attached to the appendix as Exhibit E. During that recording, Deborah McGee identified that this was the fifth vehicle that was being added to the policy. In fact, she counted them out, 1, 2, 3, 4, 5. On that same policy, on the deck sheet, which is part of this record, there are only 2 drivers identified. When this policy was initiated, there were 2 drivers identified. This was the 5th car being added.
Would you agree that the parties are not disputing whether there was fraud, meaning at least silent fraud in terms of the application? Does that seem to you to be a contested point? Because the issue is really the not innocent part, correct?
I do think that there's an issue. I don't think that it's important for the innocent third party, but I don't believe that there was fraud. If you look at Exhibit E, which is a transcript of the entire interview.
Well, let's just jump to, if it's not important for the issue in front of us, why don't we jump to the issue in front of us?
It was only important because you asked. I didn't want to ignore it.
Okay, no, that's fine. It just seemed like you were focused. Good answer. Go ahead.
Okay. So with regard to the first factor, that has to do with the ability to investigate and to have found the problem that they then found after, when it was too late for either the insured to fix it or for them to tell them you don't have coverage. What they did know was that there were 5 vehicles. The
insurance company didn't ask.
They didn't
about
ask.
ownership. They didn't do a title search, or if they did, it didn't find what should have obviously been found.
They didn't ask. They did ask, who's the primary driver? They didn't say, who's driving 5 cars? Are there any, you're adding a car, are you taking one off? Are there other drivers that we should know about? And the whole dialogue was a question and answer dialogue. In my review of it, there were no responses that weren't true. And there was no follow-up. And the thing that was really, that went on most with Member Select was the sale of rental coverage to all 5 vehicles. That there was more time spent by the call center for Member Select selling rental coverage for all 5 vehicles, and they made the sale. They added 5 more rental coverages.
To your knowledge, is there any reason why ownership is something that an insurance company would not be interested in?
Well, there can still be an insurable interest without ownership.
I know that.
And
But
so
I'm trying to play devil's advocate in terms of, is there a good reason that the insurance company is going to argue that they didn't have to ask about ownership? And that wasn't something that was required of them. What's your response to that?
my response to that is that this person clearly was calling to identify an additional vehicle and to let them know that they wanted coverage on this vehicle. They were being told certain things, right?
It should have raised a flag to say,
Right.
Why don't you ask about ownership? Maybe do a title search.
They were told they weren't listening. They were told there's 5 vehicles now. This started with 2, now there's 5. They were counted off to them. Still 2 drivers. It could, and the Farm Bureau case, Farm Bureau versus Ace, says that with reasonable diligence, could this have been found out? And reasonable diligence, it would have been found out. There was not a question that was asked that wasn't, to my knowledge, till today, that was answered in any way other than completely truthful. There is suggestion that it was withheld by the caller, but that caller listened to and answered every question completely, and they didn't have to go. They didn't rush the call. They patiently bought the renter's coverage. So what I'm saying with regard to factor 1, they were told and they didn't listen. And had they done a reasonable inquiry, as was suggested in the Farm Bureau case, they would have found this out. Factor 2, I think that it is undisputed that weighs in our favor. And that had to do with the relationship between my client's decedent and the driver, or either of the individuals, McGee's, either Debbie or Anthony McGee. No relationship. Then also for the factor 3, the nature of the innocent third party's conduct. This was a young man whose vehicle broke down and he was on the side of the road, literally on the phone with his father, who was coming to get him when the phone went dead. He did nothing wrong. His car broke down. His father was on his way to get him, and the father arrived to find him dead. The 4th factor, alternative avenues for recovery. This is what I see to be the biggest mistake that the lower court made, because this is an issue of rescission regarding a bodily injury policy. And are there alternative avenues for recovery? And I thought of that litigating the case below, because I was looking for alternative policies that are of like kind. Like, is there a relationship with the driver and an employer? Is there a respondeat superior situation where there's coverage? Is there a dram shop policy that may pay for bodily injury? All of those things were not only thought of, the depositions were taken. I went to the circuit court immediately after filing the case and got a court order to take McGee's deposition, because I have a notice issue with a dram shop defendant. We chased down every alternative policy, and there were none. The court below mistakenly identified MACP, which has nothing to do with a bodily injury claim. They identified the MACP as an alternative source for recovery. MACP doesn't pay bodily injury claims. That's palpable error in the lower court. That is the most significant of the 5 factors for this court to consider.
Wouldn't the at-fault driver be an alternative?
That would be, if that were true in a rescission case, every case, the factor would go that way, wouldn't it?
And a known driver, I suppose, not a hit and run.
But in a hit and run, who are you suing? You have to have a driver or an owner, but you still have to have, so that exception, if that were to be taken by the court, it would swallow the rule. It wouldn't the individual be able to be sued in
So-
every circumstance?
So under your reading, it's an alternative policy, not an alternative source.
Exactly. And that's because that's what we're dealing with. We're dealing with precision. So the court, when they fashioned these 5 factors, they were dealing with rescission of an insurance policy. So we're not looking for, we're looking for alternative coverage. And that's the proper analysis here. There isn't any. It was sought after. The member selects attorneys that they hired. They were at the depositions that I'm speaking of. They know that there was no other insurance. We looked for it. This is a bodily injury claim. They're here to rescind a bodily injury coverage. There is no other available bodily injury coverage. We're not swapping in PIP benefits. PIP benefits couldn't have been asked for in this case. They're not there. Even if they were, MACP doesn't pay them because the priority to get to MACP, even if it was a PIP claim, would never be reached because there's coverage from another carrier. It makes no sense why they, on that particular factor, chose that. The only thing that I can think of is that in the Farm Bureau opinion, they specifically mention when they get to that factor, i.e. MACP, that because a lot of these cases are involving PIP policies and not third party bodily injury policies. So on the PIP policies, that is an alternative, and it's only mentioned in that case as an example. In this case, we did have other possibilities. Mr. McGee ran a business. We conducted discovery on whether that business had a policy that may have covered this. There wasn't any. We did discovery on a potential dram shop case. There's no other policy. These are real world. We did go looking for these answers. There is none. The court below on their own, no one argued. The member select didn't even say, hey, what about MACP? The lower court just did it on their own, and it makes no sense. It was sua sponte, and it doesn't apply to a bodily injury claim. That's the most significant of the factors. There are others. That's the 4th, the 5th one, which I think also was wrongly decided, is to say that to do otherwise in a case would be to simply substitute the insurance company for the claim of the claimed fraudulent insured. And it doesn't substitute them for it. All that it does is give my clients an ability to make a partial recovery. This is an enormous loss of a 22-year-old engineering student at Kettering that was killed on the side of the road. His case is not worth $250. It's worth way more. Even if we make this recovery, this is going to be $250 of an enormously uncompensated claim. They are not being substituted in for that individual. That individual is still going to be responsible for a very large judgment that will go uncollected because this policy at $250 isn't enough. So it certainly doesn't substitute that carrier in for a fraudulent insured. Again, going back to one of the questions that you asked me, do I admit that this is a fraudulent policy? No, I don't. It's not my client, but I don't agree that it's a fraudulent policy because all of the questions that were asked in Exhibit E of our brief to Deborah McGee were answered truthfully. They didn't ask, they didn't conduct a meritorious, appropriate, complete investigation, and they initiated it. There is a rule that's mentioned a number of times that says, well, they don't have a duty to investigate.
So in terms of the Markman factors, you've identified 1, then you jumped to, I think, 2, then to 4. You only need 1, correct?
No, not necessarily. You can weigh them. I think the ones that went in the lower court, they ruled erroneously on factor 1. Number 2 was decided, and I think uncontested, that it was decided in my client's favor
So it's three.
And so was three. Four was the MACP. That's the biggest issue that I think they got wrong. That's the one that I don't think anybody could say that that was an appropriate finding. And then number five, as I just said, you're not substituting those in. So sorry for the long answer to your question. There were two that were found in my client's favor in the lower court.
Mhm.
The other ones, I think, number four in particular, palpably wrong. And the other two, for the reasons already mentioned.
But if one is changed in your favor, you prevail
On appeal.
on appeal.
I think that it should and at least be sent back down for the court to reconsider.
Well, because it's for the trial court in the first instance to do the weighing, correct?
Yes. Thank you.
All right, counsel, go ahead.
Morning, and may it please the court. My name is Trent Collier and I represent Member Select Insurance Company. I want to start with my common ground with my colleague and then turn to where we part company. This was a horrible accident that took the life of a young man, and I don't know anybody who could look at the facts of this case, especially a parent, and not have their heart broken. It is an awful case. But our task today is to apply the Markman factors to determine whether rescission was appropriate. And the first place that we part company with the plaintiff is on the first factor. Their argument is essentially, we didn't ask the right questions. We didn't go find the right information. Our position is that argument violates the Titan case and the Bozzi case, both of which reject the idea that there's this easily ascertainable defense, that if the insurer could easily ascertain that what the insured said was wrong, then they should have done so. I know this court has mentioned due diligence in cases after Titan and Bozzi. Those cases are wrong. And this court is required to follow the Michigan Supreme Court cases rather than the subsequent cases from this court.
What if we follow the subsequent cases from this court? Does that do you concede that that means you lose on the first factor?
I don't concede that because this is what makes this case very different. The plaintiff, not the plaintiff, sorry, Ms. McGee admitted she was going to give these facts to the insurance company. She knew she had to do that. She said so. And she later said, I just didn't get around to telling the insurance company. This is on appendix pages 73 and 74.
But
So-
isn't it? I mean, again, I didn't work in insurance world before coming on the bench, so correct me if I'm wrong. But a question about the ownership of a vehicle when you're trying to get no-fault insurance would seem to be one of the basic questions that should be on every list that the insurance company asks. It seems so obvious. Am I missing something?
But that makes it obvious to the insured too.
Really?
Yes,
Because
because
the insured is supposed to know all the requirements for the insurance laws. I mean, I get it, but it would seem to be that it's the insurance company. When you're asking between the two entities, the insured or the insurance company, which one is the least cost avoider? It's going to be the insurance company.
that's true. Perhaps that's true in an abstract sense. It's not true in this case because the plaintiff knew what she had to tell them. She knew she had to tell them that her nephew owned the truck and not her. She just didn't do it. So, whatever policy makes sense in the abstract, the question is, how do the equities work in this case? And because you have a plaintiff because you have Ms. McGee who just didn't do her job as the insured, that factor weighs in favor of Member Select.
Does your client have any duty whatsoever to ever make an investigation into anything? And if so, in what instances would that duty arise?
So I think that's a very good question in terms of the first Markman factor, kind of sounding like the insurance company has a duty to ask these things. But conversely, you have Titan and Bozzi saying there's no defense based on certain facts being easily ascertainable. So I think the only way to reconcile those two aspects of the law is to say there have to be facts that put the insurance company on notice that there's something else going on.
So if I bind auto insurance for the first time and I contact your client and I say, I have 6 cars, or I'll just stick to 5 cars because there's 5 cars in this case. I have 5 cars I'd like to insure and I own all of them. But I fail to volunteer the fact that I have 4 teenage children living in my home. Is it on me, the insured, for failing to tell the insured that I have 4 teenagers living in my house? Or is there some responsibility of the insurance company to say, I wonder if they have any resident relatives living at home, and maybe I should ask that question?
Under Titan and Bozzi, the insurance company does not have a duty to ask about kids.
So under your reading of Titan and Bozzi, what responsibility does the insurance company have with regard to any information?
When there's information that should lead a reasonable person to make further inquiry, that's when an insurance company might
You
have.
don't think that Judge Cameron's example, when you have 5 cars and you have one person calling, that might raise a flag to the insurance company, say 5 cars for one person seems like a lot of cars for one person. Maybe there are some other people in this household I should inquire about.
I don't think so. I mean, Jerry Seinfeld has about 20 cars. So there are people who have lots of cars, but
And if Jerry Seinfeld called your
Right.
member's flag, then sure. But I mean, you know, again, you have Judge Cameron's really good example, which was, you know, maybe a first time person in Michigan moves to Michigan, doesn't really understand our no fault laws, says, yeah, I've got 5 cars. You don't think in that instance that there would be that would require some further inquiry by an insurance company?
no. And the reason is that, you know, the problem in this hypothetical was 4 teenage children. And I think any reasonable person getting insurance would know that the insurance company wants to know what teenagers are driving those cars. So I don't think you have to be that knowledgeable about insurance law to know you need to tell the insurance company that your children are driving these cars.
So we're putting all the duty and responsibility on the insured and none of the responsibility on the insurer with regard to information.
No, I disagree. What we're saying is when there's information that the insurance company receives that kind of suggests there should be further inquiry, that's where they can have a problem. But when they don't know anything, as in this case, or as in the hypothetical, then there's no duty under Titan and Bozzi to inquire further. Those cases are very clear in saying that there's no easily ascertainable defense. And so if the court is going to say the insurance company should have asked questions, it's violating Titan and Bozzi.
I guess I have trouble it's one thing to ask some esoteric question about some issue that maybe arises once in 1,000 cases. I get that. But this just seems like such a fundamental piece of information that I would think any insurance company would want. Who owns the vehicle? I just find it odd that your client wouldn't have any responsibility into inquiring into that area.
But I think the problem with that question is that it's presuming that it's easily ascertainable for the insurance company. And that's exactly what the Michigan Supreme Court said is not a valid argument. So that's the first factor. Second factor, I think we all agree favors the plaintiff. I don't doubt that. The third factor, and I'll be candid on this one, I'm wrestling with what the innocent third party means. I think most cases might interpret it to mean just the injured party. But I think what the third party thing actually refers to is a third party to the contract. And because Anthony McGee was a third party to the contract here, we think the court should consider his malfeasance in applying this factor. The fourth factor, this is where the court was talking about whether there's other avenues to recover. It sounded to me like the plaintiff was saying that maybe there needed to be an insurance policy
Are you
there.
saying for the third factor, we should be considering the drunk driver's conduct as in the balancing test for the third factor? I'm not, because I took it to mean you're balancing the negligence of the innocent parties, meaning the plaintiff in this case and the insurance company, which did no fraud and balancing that. But you're saying something different. You're saying it's the drunk driver.
Well, and I will concede that if the court looks at the injured party, there's no question that favors the plaintiff. The thing I'm struggling with is, what does it mean to say that the third party in the context of this accident? Third party to what? The only way I could make sense of it is to say it's a third party to the contract. And that would be both the injured party and Anthony McGee. Otherwise, I just don't know what it means to say third party. But I think this is very unclear in the case law. So I don't have a great answer. That's just my problem was that I just couldn't figure out third party to what, if we're looking at a kind of a tort context. And if it's a contract, then it has to be both McGee and Connor Clancy. So for the fourth factor, there's a question about other sources of recovery. It doesn't have to be an insurance policy. What the Markman factor says is other avenues of recovery. So there are other avenues of recovery, and that's the lawsuit against Anthony McGee, which they filed and then conditionally dismissed.
But I think if I recall correctly, the trial court judge did specifically reference the MACP. Is that correct? My memory correct?
Yes.
And is there any question that that's a mistake?
No.
Okay. So even if we agreed with everything else you said this morning, understanding that it's the trial judge's job to weigh these factors, not the Court of Appeals, doesn't have to go back just based on that alone?
I don't think so. I mean, this is an area where kind of right result, wrong reason might apply, because the trial court was wrong about the I'm sorry, I'm getting the letters wrong.
Yeah.
Yes, sorry. But there is another avenue recovery that the court can see, and that's Anthony McGee.
Yeah, but let's look at this practically. The trial judge thinking the MACP might step in, that is a well-funded source of, potential recovery if it applied here. Mr. McGee, who knows whether Mr. McGee has any money, and that very practical reality might have played some factor in the trial judge's analysis. Wouldn't you have to agree to that?
I think the problem is that the plaintiff didn't produce any evidence that it's impossible to recover from him. Like, we can't just assume that there's no recovery possible from Anthony McGee because the record wasn't developed on that point. So that, and so I think for the fifth factor, there's really no dispute that it would relieve a party of tort liability if rescission were not possible. The bottom line for us is the thing that makes this case different from most cases is that Ms. McGee had knowledge of what she was supposed to tell the insurance company, and she admitted that she just didn't do it. That makes it different. And there's also a concern about protecting a criminal party who did something fatal. And that party should not be shielded from liability, unless the court has questions.
Well, I got to ask you, Mr. Collier, what are you reading?
Frederick Buechner was one of my dad's favorite theologians, and after he passed, I got those books, and they're just wonderful.
I haven't delved into the. Mr. Collier and I share an undergraduate degree in religious studies. However, in both at Methodist schools, if I'm not mistaken. However, Mr. Collier got his master's in theology at Harvard Divinity School.
And then I fell from grace and became a defense lawyer.
I wasn't gonna say it, but
I'd already told him that numerous times. Well, I'll have to look into that.
Yeah, Beekner, he's just wonderful.
I'll have to, thank you. Always nice to see you, counsel.
Good to see you. Thank you.
Any rebuttal?
Just briefly. The first factor, in the Michigan Supreme Court case of Farm Bureau Insurance at page 906.
Mr. Collier, you kind of gave up the ghost here.
I just wanted to check Mr. Cook over there. He's doing okay, and now I'm ready.
Well, he needs hand holding. We understand.
At 906, they point out that the Michigan Supreme Court
Could you repeat yourself? I lost your point.
Of
in
course.
Shuffle. Go ahead.
in the Farm Bureau case 503 Mich, 2018, after the Bozzi case, on page 906, the court states addressing factor one, and I'm going to read, I know that wasn't good earlier, but I
I'm
can't,
sorry,
I don't have it
counsel.
committed to memory yet.
Can you give me a cite on that so I can, do the Mitch Miller thing and read along with you? It's 503.
Mich, 903,
Thank
but
you,
it's
sir.
at 906.
Okay, thank you.
And they listing the first factor, they say, first, the extent to which the insurer in fact investigated or could have investigated the subject matter of fraud before the innocent third party was injured, which may have led to a determination by the insurer that the insurance policy had been procured on a fraudulent basis. I think that addresses which court is saying that factor can go the way that it is. This isn't a court of appeals opinion that's found in. It's in Michigan Supreme Court opinion after the Bozzi case was decided.
Is that post-Titan?
I didn't look at the date of Titan. I can tell you the date that it was decided. I don't remember the exact. This was November 21st, 2018.
yeah, that's after Titan.
It's time for Titan.
So, and once they've engaged in it, there is a rule. There is a rule that says they don't have an obligation to do it. But when you do it, it's like the tort duty. There's no duty to do something, but when you assume a duty, you have an obligation to do it reasonably. Same concept here. And the other one of the other things that the courts decide is that you protect people who act on things and deserve protection. They did nothing. They did not. They had knowledge. They asked questions, and then they asked questions to sell more policy. Other sources of recovery. Again, that is if that's allowed to be a factor in an innocent third party claim like this, that'll swallow the rule because there's always someone.
Oh,
There's just no coverage there.
in Titan and Bozzi, you could read it as saying that there's no negligent duty. There's no duty that if you don't do, you're going to, the insurance companies can be found negligent. But if they don't do it, it might simply be a factor that weighs against them when it comes to a rescission between two innocent parties.
I agree. And I think that the lower court should just be reversed, or alternatively, this goes back with instructions for them to have a hearing consistent with your findings. Thank you.
Thank you.
Thank you, counsel.
Thank you both very much. That matter is submitted. Turning now to item number 19, Colliers International Detroit versus Signature Associates. It's a consolidated case. Items number 372916, 373163, and 375079. We have one attorney arguing remotely. And if we could,
All the lawyers come up.
yeah. Do we need any more chairs? All right, so I'm not sure if there's been any determination about how you're splitting up your time, if at all. Once you-
Excuse me, Your Honor, Rick Bennett for the Frank Spencer Group. No, we have not had an occasion to talk about how we're gonna split up the time. Maybe that we've got multiple appeals, the primary claims between Colliers and 14 Mac, and then we're an indemnity claim to that. So I don't know if
All
that
right,
makes
well,
any difference. to
You
the
both
court.
have half hour. We'll keep you on task. Go right ahead.
Just want to be clear that Alex Benson on behalf of Signature Associates is present by Zoom, Your Honor.
All right, very good.
Good morning, Your Honors.
Morning.
Fozia Daher on behalf of the appellant and cross appellee 14 Mac. Just as a matter of housekeeping, does the court prefer that I address the cross appeal issues also at this time?
Your time. Spend it how you
Okay,
like.
perfect. So I'll present the issues in chronological order and I'll reserve whatever time I have for rebuttal.
So how disappointed were you when you saw my name?
So
on there?
disappointed.
I
I'm gonna-
thought so,
Yeah,
yeah.
I have no shot.
He just genuinely hurts me.
I don't.
I mean, that's a large club.
Well, they have regular meetings. She's president.
So I know the court is very well aware of the facts and issues of this case. But I think it would just be helpful to frame the overview because we do have a lot of arguments today. So this,
I'll just let you know, this is a fact intensive case. We all know the facts. I think your time is not well spent.
Okay.
Going through the facts.
Okay, perfect. So I'll just jump into it. The first issue on appeal is the trial court's summary disposition ruling that Colliers was a third-party beneficiary of the executive leasing agreement between 14 Mac and Signature. So the parties all agree that Colliers can only be a third-party beneficiary if 14 Mac and Signature undertook an express promise directly to benefit Colliers. The relevant contract language here says that Signature will cooperate in good faith with outside brokers and agents, and that in any lease procured by Signature with assistance of another broker or agent, 14 Mac will agree to pay a leasing commission to such brokers or agents. Applied here, the question really becomes whether the lease that was ultimately procured for Suite 500 was done so with Collier's assistance. And the issue boils down to whether Collier's pre-termination activities carried forward and qualified as assistance for the ultimate lease that was executed. 14 Mac's position is that this is.
Is it the lease that was procured, or is it any lease that was procured?
The contract says any lease, but applied here, there was only one lease that was procured.
That's
through
true.
the relevant parties.
That's true. Okay.
So the issue really boils down to, like I said, whether its assistance, its activities before it was fired qualifies as assistance. And our position is that this is a factual question that was not proper for determination at summary disposition. And there are a lot of facts in this brief, as Judge Cameron just recognized, a lot of facts regarding what Colliers did before termination and including its showings at the entire property, its failed negotiations on a different lease, and introducing DSG to the property. But there are also a lot of facts regarding its lack of involvement after its termination. And
Well, but just because it was terminated, that doesn't mean that it didn't provide assistance prior to that. And the executive leasing agreement doesn't suggest that a terminated broker would then be ineligible for any fee, correct?
correct.
Okay,
Um,
so if there was some assistance prior to termination, wouldn't that alone satisfy the conditions here?
we disagree because we don't think that assistance was continuous.
Or does it say it has to be continuous in the agreement?
It doesn't say that, but we don't believe that that assistance helped in the ultimate lease because there was a clear break in that Colliers only did so much as to Suite 100, the first lease. All of the testimony, all of the evidence at the summary disposition stage showed that Colliers did nothing at all to identify the Suite 500 property, to discuss the
But the Suite 500 property was within the same, is this a mall?
It's a giant, like a
Outdoor
million,
type thing.
million square foot warehouse space that has warehouse, retail.
Okay. I'm just gonna call them mall for lack of a better term. But Suite 100 and Suite 500 were in the same building, correct?
Correct.
Does it really matter that much that you got, that Colliers seem to have done some assistance with regard to Suite 100, but rather than getting 100, the lessee decided to do something next door or across the building? That seems to be not the most material distinguishing point.
No, it isn't.
We believe that the assistance before isn't sufficient because DSG had no knowledge of the remainder of the property at the time. All of its knowledge, all of Collier's assistance was only on Suite 100. And DSG is the one that reached out to 14 Mac to ask about what else there is on the property. At that
So in your
time,
mind, it does matter.
it does matter
Okay.
because it didn't know about it and it worked directly with 14 Mac to explore those other options. And it's also in the record that DSG found the property itself. Colliers may have introduced DSG to 14 Mac, but it didn't research and find the property on its own. So
How significant is that, counsel? And I understand de minimis is gonna be your argument here, but I'm sure brother and sister counsel are gonna tell us. Without our client, your client would have never known about any of this, which is what I believe is the basis of Judge Schwartzel's question as well. So don't they get some points, if you will, for at least introducing the parties to one another and going to this, being the first to identify this location? And if
Your
not-
Honor, would it be possible for me to jump in and help sister counsel? Because I was a trial.
Hold on,
attorney.
counsel. Here's how this is gonna go. You all were supposed to square this away before we began. You didn't.
Sorry.
So if she runs the clock out on you, so be it. Go ahead.
Sorry about that. Would you like me to repeat the question?
yeah,
Apologize, Your Honors.
That's right.
Can we mute him?
Yeah, if you could please, you just mute yourself. I should have said that for
I
anyone.
won't do it again, Your Honor.
Go ahead, counsel.
So Judge, I think your question was, should Colliers get any credit for at least introducing the parties?
Right, that was it. Yes.
The question is whether that introduction is enough to be assistance in the procurement of the ultimate lease. We don't think it is, because there was a clear breakdown and DSG is the one who found the property itself. It could have stopped, once it fired Colliers, it could have looked at other properties.
When you're referencing properties, I think
That
one
were,
area where we're kind of crossing wires is this could be seen as one large property that was subdivided. And so Colliers was at least involved in the introduction. I understand that there's questions about whether somebody else was involved, but there's no question that Colliers was involved in the introduction of 14 Mac and DSG in terms of DSG becoming a lessee here. And it was just a subdivided piece of that property that ultimately was where the lease was at. So when you keep saying property, that it was DSG that identified the property, it's really DSG identified the subdivided piece of property or the lot, correct?
when I refer to property, I refer to the entire property. And then so DSG identified the property and it asked Colliers to help it procure the Suite 100 space on the property.
Okay, help it. Sounds like a lot
Assist it.
like assist.
That that lease ultimately didn't work out.
Okay.
The negotiations failed.
So for you, for your client, 14 Mac, to prevail, we really have to see this distinction between the lots and the fact that there was no lease on lot 100, which the record is clear that there's a clear separation between lot 500 and lot 100 in terms of assistance. Colliers, is there any dispute that if there had been a lease on lot 100 that Colliers would be entitled to a fee?
I don't think so.
Okay, so it's really, that is the line you're drawing, and it's whether we agree with it or not.
Yeah, that's the line we're drawing, and not so much as between the properties, but between the pre-termination and post-termination.
See, to me, the reason I'm struggling a little with this argument is here Colliers takes the client to a property and says, here's a property we think you might be interested in. And it doesn't go through. But then the same client makes a call then to your client and says, hey, I like that property. Is there anything else that's available? So I don't see where DSG, and of course you don't have any control over them because they're not your client, but where DSG made a split, if you will, between Suite 100 and Suite 500. They were very interested, obviously, in the property. And then I would think the question wouldn't it become whether Colliers was responsible for DSG knowing about this property?
For knowing it about the property in the first place?
Correct.
I think that goes back to your earlier point too, whether, the introduction and putting the
Right.
parties together is enough. I see the court that's our position, and the court is going to disagree with that.
No, I'm not saying I disagree. I'm trying to work through it, if you will. And
Okay.
I think that they should be entitled to some credit, if you will, for at least exposing this particular property to the client. And your contention is no, because they exposed a particular aspect of the property, but not ultimately, they had nothing to do with ultimately where the lease was written. Is that your argument?
That is my argument, but there's also so much more that goes into the eventual execution of the lease than beyond just the introduction. And there are LOIs. There were weeks of LOI negotiations that went through. There's lease agreements and negotiations in that regard. So finding introducing the parties to the property is just one aspect of it. And we think the court entirely disregarded all of the post-termination facts. Even the fact that Colliers was terminated was not really mentioned in the 20-page opinion, but there was so much more that went on without Colliers' involvement that makes it difficult to justify that assistance and that commission payment.
One last question for you, and you just alluded to it. Is it your position or a position or a client rather that the termination of Collier terminated any and all agreements or any and all duties, if you will, of any of certainly of your client? I don't ask you to speak to anybody else.
That's kind of a broad question.
It's a very broad question. And then we're gonna dig down.
There was no contract between 14 Mac and Colliers. 14 Mac would only have a duty if Colliers did assist. That's the only duty that could.
Well, let me ask it in maybe a better way. And that is, what emphasis do you think this court should put on the fact that Colliers was terminated?
We think the fact that Colliers was terminated shows that there was not a continuous assistance in shows that there was not a continuous assistance, number one, in executing the entire lease, and number two shows that there was no involvement whatsoever in the actual Suite 500 lease that was executed. If the court disagrees with that, 14 Mac's position is that at the least, those facts need to be considered to create a dispute of material fact that should have been developed more at trial. And it was improper for the trial court just to ignore all of those facts.
As always, counsel, I very much appreciate your candor. You have excellent briefing and I appreciate your oral argument.
Thank you. I appreciate that. So I'll turn to the next issue on appeal, which is the trial court's findings and conclusions following the bench trial. This is the indemnity issue. So through summary disposition rulings, the trial court found that DSG breached two indemnity clauses in the lease by representing that it had not used the services of any other broker or agent besides Signature. So the trial court found that 14 Mac is entitled to indemnity from DSG, but that there was a question of fact for trial on whether 14 Mac acted grossly negligent or with willful misconduct, so as to bar the indemnity claim. And the trial court found that ultimately the claim was barred. On appeal, 14 Mac asks the court to reverse that conclusion because the trial court disproportionately relied on the fact that 14 Mac edited out Colliers from the LOI despite DSG's reinsertion. So the question is really whether that conduct meets the very high burden of gross negligence or willful misconduct. And for parties to a contract, we don't believe it does. Gross negligence is conduct that is so reckless as to demonstrate a substantial lack of concern about whether an injury results, and evidence of inaction or that the defendant could have taken additional precautions is not sufficient. Willful misconduct under Michigan law requires intent to harm or indifference as to whether harm will result. 14 Mac doesn't dispute that it cut out Colliers from the LOI. It acted purposefully in doing so, but that purpose wasn't injury to Colliers. It wasn't simply that 14 Mac didn't care about the effect of Colliers, but 14 Mac had a leasing agreement that said it would only pay cooperating broker fees to a broker that assisted, and it acted based on the information it had, and that information led it to believe there was no reason to keep Colliers in. The trial testimony firmly established that DSG told 14 Mac that it fired Colliers, and for weeks there was no communication or interaction between Colliers and 14 Mac to suggest otherwise. Every witness agreed that Colliers didn't do anything regarding the Suite 500 lease. It didn't identify the space, it didn't show the space, negotiate the lease, it didn't attend the site visits. Suite 500 only came up again after Colliers was terminated. 3 weeks had passed, and then 14 Mac suddenly sees that Colliers is in the LOI drafts. 14 Mac thought it was a mistake, and the court can disagree with that perception of it being a mistake, but that doesn't rise to the level of gross negligence or willful misconduct. DSG also had the opportunity to clarify to 14 Mac that this was not a mistake, but it didn't. It just said, we only inserted it because we're under the understanding that there was a separate agreement between Signature and Colliers for commissions, but if there's not, then we're fine leaving it out. Ultimately, DSG agreed to leave them out and entered into a lease wherein it agreed that there was no cooperating broker. And again, 14 Mac took DSG on its word. Michigan courts have never held that intentionally that contract terms transform a commercial dispute into willful misconduct. And if that were the rule, then every adverse contract enforcement would carry punitive consequences. 14 Mac's position is that the trial court made a legal error by treating this notice of an unproven commission as a substitute for gross negligence or willful misconduct. As to common law indemnity, 14 Mac is also entitled to this indemnity because there was no casual or active negligence on its behalf. Active negligence requires a duty owed by 14 Mac, which there wasn't one here.
Can I just want to make sure it is, you have 10 minutes left. I just want to make sure that you keep that in mind with regard to others. Go ahead.
Thank you. Any fault by 14 Mac was passive and attributable to DSG's representations. If the court doesn't have any questions on that, I'll turn to the cross appeal issue, which is DSG's motion for attorney fees. We believe the court should also affirm this and hold that the trial court did not abuse its discretion in denying this motion. The reason for this is under Pransky, DSG was required to assert a claim against 14 Mac to enforce this fee shifting provision in the lease.
I think this is well explained in your brief.
I think it is. And if the court doesn't have any questions, okay, perfect. Thank you.
All right. All right, Mr. Benson?
Thank you, Your Honor. Sorry for before. I was really trying to be helpful, not harmful, so you understand.
I understand. Go ahead.
Okay, so I want to clarify because I think there's an incredibly important point that is sort of being brushed over that I think I can illuminate for the panel. First of all, this particular building is not like a strip mall. It is a 1.5 million square foot building that used to be the Art Van, #1, front of the building on 14 Mile was the showroom, then an office building, and behind all that, warehouse. The reason Space 100 was so exciting to, for instance, both of these parties, meaning Ashley Furniture, which is DSG, and ultimately the people who got the space, Gardner White, was they both wanted this signature spot. So when our client, which was 14 Mac, when the negotiation fell apart with DSG, Ashley was furious because not only did they not get the space, their arch enemy, Gardner White, got the space. And that is why they were fired. This isn't a strip mall where we can put you into space 100 or space 200. The primary point for everybody involved was getting this showroom and office building and then some storage space and a loading dock. So once.
But what about the argument that merely being involved in the initial identification and introductions would satisfy what seems to be a pretty broad contractual language with regard to any assistance or assistance with any lease?
So here's my response to that, Your Honor. So I don't know what city you live in, but I'm going to just pick Birmingham by instance. There's a building called the Willets. They have 80 condominiums. A person hires Caldwell Banker to take them to go see Unit 303. It's a unique condominium in the building they want to buy. They lose the deal because the purchaser believes their broker did a bad job and didn't get the deal closed. They fire that broker. A few months go by and they see there's a new unit available, 404. It's not quite what they wanted, but it happens to be in the same building. And they say, okay, you know what, take me to see 404. But I'm not working with that old broker anymore at Caldwell Banker. I'm only using you through Realtor One because I fired them for screwing up the deal. They take them, they see 404. It's an entirely different project. Instead of having an office and a showroom, it's merely a loading dock and a storage facility warehouse. And they say, okay, I guess I'll get that. It's totally unique. The first company, in this particular case, Colliers, had nothing to do with it. And by the way, everybody in the commercial real estate universe knew of this space. It sat vacant for several years. It changed hands several times after Art Van. So there was nothing unique there. And as I understand it, that's why DSG, Ashley's parent, went back to 14 Mac directly and said, look, we still need some warehouse space. Okay, so do you have any warehouse space you want to show us? And then they said, what about Colliers? They said, no, we fired Colliers. We hired them because we wanted to get the office building. We wanted to get the showroom in front, and they didn't get it for us. That's what we really wanted. So if you've got some warehouse space, we'll look at that and deal with you directly. So from my vantage point, I don't see how Colliers had anything to do with that at that point. And that's the distinction that I wanted to draw to the court's attention.
All right. Okay. Thank you.
It's the exact same thing as sister council.
Yeah, I mean, you got 2 minutes of rebuttal, and you can decide how you want to handle that. Go right ahead.
Morning, Your Honors. Joanna Abramson on behalf of the Colliers. The real central issue in this case is not the facts of the termination or whether there was or not. The fact is we have a contract. The contract is written and the contract is the executive leasing agreement. I call it the listing agreement because 14 Mac entered into a listing agreement with Signature. And the language of that listing agreement is absolutely clear with regard to a cooperating broker. The cooperating broker has to be licensed, and the cooperating broker has to assist in the procurement, Signature's procurement of a lease, any lease at the property. Judge Swartzel, the property is a huge warehouse, and at the time that Colliers showed the property, twice in fact, it was a huge undivided property. Over time, it became divided more into suites, but there has been no dispute that Colliers introduced DSG to the property, directly introduced it to 14 Mac by letter.
What about opposing counsel, both opposing counsels point that to consider this or to talk about this as a single property really doesn't reflect the situation here, which was you had this beautiful not storefront, but kind of front part of the property that was a key for DSG. And then you had this kind of lesser properties in the back. And because of Collier's actions or inactions, DSG lost out on that premier suite or lot. And they pretty much had to settle. I think that's probably a correct way of looking at this record, that is settle for property in the back. That's a material distinction, and any assistance that Colliers provided on the first part that fell through really shouldn't carry over to the second.
That might be a good argument if that's all Colliers did, but that's not all Colliers did. Colliers showed the entire property, not just the retail space that we're talking about. DSG was interested in the retail space, but it was also interested in the warehouse space. It was interested in both. And it's not because of Colliers in action. It was because of 14 Mac, while they were considering a lease proposal after having signed a letter of intent.
I think we can skip over that.
That's
I mean, there was some,
right?
Yeah.
But what we're saying here is Colliers did show them the whole property, and then Colliers assisted DSG in negotiating the actual LOI for Suite 500. And that has been shown by the evidence, Exhibit K in Appendix 1 and Exhibit O. It shows that Colliers agents made revisions to that LOI for Suite 500 twice. Furthermore,
is this the paperwork that 14 Mac and Signature kept asking, why is Colliers on here? I thought they were fired. Wasn't that, there was conversations that.
In response, 14 Mac said, get Colliers off of here.
Sorry, 14 Mac.
Yeah, 14 Mac said, we do not accept Colliers' insertion. Colliers wasn't a part of it, but they were. And they could see our initials. They just decided they weren't going to accept it. And why? Because they were going to have to pay more of a commission. And they, instead of paying a 5% commission, paid 4%. And they paid all of it to Signature. Now, it was Signature that had the responsibility under the clear language of the listing agreement to procure the lease. 14 Mac doesn't dispute that Signature procured the lease, but the facts showed that Signature had no more involvement in introducing the property or showing the property than Colliers did. The Colliers position is we didn't have to be the procurer of the lease. We had to assist Signature in procuring the list, and that they did. This termination issue is just a big red flag because the listing agreement doesn't speak to the termination or the agency relationship between the tenant, who is DSG, and any cooperating broker. It only says that the cooperating broker has to assist signature. And we demonstrated to the trial court at summary disposition with a large exhibit of chronology, Exhibit W, that showed Collier's assistance, whether you like it or not, before and after they had issued a termination letter. So it was clear that while they said they were terminating, they turned right around and asked us to assist them in getting this piece of property. The trial court went on to have a trial on the facts of this issue. We were not involved because that was the issue of indemnification. But the trial court record shows and confirms that not only did 14 Mac know Collier's assistance was, but Collier's did. And because Collier's knew that, Signature knew that Collier's had assisted in the lease and had received a phone call from Collier's and admitted at trial that they didn't do anything about it. They didn't try to convince 14 Mac that Colliers should have gotten its commission, and it accepted a 4% commission rather than just a 2.5% commission, that both of them had knowledge. For purposes of our summary disposition, the trial court already made findings of fact on that issue. There are really two key issues in this case legally. One is, was Collier's properly considered a third-party beneficiary of this contract? In their briefs, 14 Mac seems to have objected to that ruling, but today, an oral argument at least, they seem to accept the fact that Collier's is part of the class of third-party beneficiaries called cooperating broker. So really the only issue left.
I didn't hear a concession today.
I didn't either.
Okay, well,
The briefs say what
the
they say.
briefs say that what they say, and I'm not going to re-argue that then, but I think that it must be made clear to the court that some of these facts are incorrect as far as what they're saying about termination. Whether or not it was never communicated to Collier's that they were terminated because they screwed up on this deal. They were simply, they got a letter in February of 2022 that said, we are terminating your services. But the facts also show that DSG turned around and contacted Collier's again about this specific property in order to manage an LOI for Suite 500. So even if there was a termination, that termination was obviously reversed. And in any event, the plain language of the listening agreement does not provide that Collier's had to be an agent at all of DSG, solely that it assists Signature. I think I've kind of answered what maybe some of the prior questions might have been, but are there any other questions?
I don't have any. No, thank you.
I guess I reserve my time if there's any rebuttal.
There's no rebuttal, but go ahead.
If I may.
Counsel, did you have something?
Yeah, I just wanted to It's in your brief. I don't.
Yeah,
I wouldn't.
I think we're all set.
Stress about it.
I think I made this point clear, but maybe not. The commission was paid to Signature. There was no dispute here that Signature got a commission for
Right, right.
procuring.
They got the 4%.
Yep.
Thank you.
All right, you got 2 minutes rebuttal.
Thank you, Your Honor. I appreciate it. Very briefly, Rick Bennett on behalf of the Frank Spencer Group, Tim Kramer and Jeff Turner are also co-counsel here with me today. And I'm just going to address a couple of things. One has to do with the contractual and common law indemnity claim. 14 Mac made the decision that it didn't believe Collier's was entitled to a commission under the listing agreement. And they ultimately excluded them from the LOI and ultimately excluded them from the lease and precluded them from getting a commission. We're not a party. DSG was not a party to the listing agreement. Matter of fact, Your Honor, we weren't even aware that there was a listing agreement until after the lawsuit was filed. All my client was told was that there was an agreement between Signature and Collier's, get them paid a commission. We don't know what that was. That's not we're the tenant. The brokers work out what their payment issues are. They had a separate agreement. That's all we were told. And DSG did everything they could to keep them in there. They were constantly told repeatedly by 14 Mike that there is no such agreement. They never even told us there was a listing agreement. They just said there is an agreement, they're not entitled to a fee. So when counsel for 14 Mike stated earlier that we had an opportunity to insert them, we did. 3 times we inserted them, and 3 times they got removed by 14 Mike. So DSG was doing what they could. There's also a comment made that DSG, that 14 Mike took DSG at its word that Colliers was not a cooperating broker. Your honors, we don't even know what that term was until the lawsuit was filed. It was never brought up. That was never brought up in any of the discovery, any of the evidence presented at trial. We were not aware of that term. That came up when Colliers sued, that they're entitled as a cooperating broker, but that term was never discussed. All that DSG was told was, can you protect our commission? We're entitled to a commission. And they did that. They took multiple steps to protect their commission in regard to putting them in the LOI. 14 Mac knew its decision would harm Colliers. I don't know how they could say that they didn't think it was going to harm them. You're denying them and depriving them of a commission. It also knew Colliers was expecting a commission, because we repeatedly telling them that they were. Whether they are or not, your honors, Judge Valentine has ruled on that. We weren't aware. We're just saying they're telling us they are based upon some agreement they say they have with you guys.
Just need to wrap it up.
Yes, your honor. And so what I would also, then I want to move, I want to point those out. And I think the trial judge did a very good job of the facts and marshalling everything in regard to the indemnification issue. As to the prevailing party attorney fee, just want to touch on that very briefly. We argue under Fleet, obviously 14 Mac and Signature argue that Kransky controls. And quite honestly, it's really tough when you're looking at them, which one controls. I have to admit that myself, your honor. But the language of the prevailing party fee of provision seemed to be substantially different in Fleet than in Kransky. As a matter of fact, in Fleet.
Okay, I think we're past the point of arguing cases right now.
Okay.
Okay.
I'm just going to talk about the 2 prevailing parties. That's the only thing I had.
We got it. All right. Thank you very much. All right. That matter is submitted. That concludes our 10 o'clock docket. Why don't we take a 5-minute break? Thank you very much.
Did we ask for this bailiff? Because I kind of like the other guy like that.
He's a Michigan man, so that's exactly what we need.
See, I knew there was a reason I liked the other.
All right, turning to item number 20, it's Cooper versus St. John's Hospital, item number 373583.
Good afternoon. May it please the court, I'm Ernest Jarrett. I'm appearing on behalf of the plaintiff's appellants. I'd like to reserve 3 minutes of my time for rebuttal.
It's been a while since I've seen you, Mr. Jarrett. You must have been making money then.
I wish I had been. I think my wife has just kept me busy and I haven't been visible lately.
I know how that goes. Well, good to see you again, sir.
Very good to see you. Thank you. This matter, I'm sure the court will recall, arises from my client's visit to the emergency department at St. John Hospital, where she was induced to terminate her pregnancy medically because she had been misinformed that she had an ectopic pregnancy. And even though she and the father of the child both wanted additional time for a second opinion or to sleep on it or that sort of thing, she was induced to go forward with the medical termination of the pregnancy by the defendants. Now, this matter is here by virtue of the court's grant of partial summary disposition and a motion that was filed by the former defendant, James Denier. James Denier is no longer part of the case. He's not an appellee. But the appellees who are present today were his co-defendants, and they did not file a separate motion. They merely joined in his motion. So they are limited in terms of issue preservation to the extent of Mr. or Dr. Denier's motion. And after I filed a response to that motion, Dr. Denier filed a reply, which the appellees did not join in. So they don't have the benefit of whatever, preserving whatever issues Dr. Denier may have preserved, even though I submit, as I did in the court below, that he filed an improper reply brief because it went beyond the scope of just rebuttal. Now, this, in his motion, Dr. Denier relied exclusively on MCL 566.132, parents G, which is not a standalone statute, but it is merely a subsection of the codification of the statute of frauds. And as a codification of the doctrine, which has been in existence prior to the American jurisprudence, it merely places in statute form what was always the case with respect to the doctrine. And it was subject to all of the conditions or circumstances which would remove an oral contract from the statute of frauds. That would include part performance, that would include a contract that can be accomplished or completed within 1 year. That would include detrimental reliance by the person who relied upon the contract. And those things didn't change by the codification of this particular statute. Now, the purpose of the statute of fraud is well documented and spoken about throughout the years in the Michigan jurisprudence. The statute of frauds is intended to prevent fraud, not to create fraudulent circumstances. And by fraud, I'm not talking about any type of intentional deceit or misrepresentations. I'm merely talking about the equities of allowing a party to escape their contract merely because the statute of frauds might otherwise suggest that because it's an oral contract, it cannot be enforced. The statute of frauds was never intended to aid in fraud. It was intended to prevent fraud. And in this particular circumstance, my client relied upon the representations and the inducement of the defendants. She made a decision against her better judgment and against her wishes to terminate a pregnancy. She took an injection because she was told that she had no options, no choices. If she didn't do this, she was going to die. And then 2 days later, they say, whoops, you made a mistake. And we're sorry, but since you started this process, you have to now complete it because, if the baby will not survive to term, but even if it did, it would likely be suffering some defects. So with that in mind, I submit that the trial court made an error when it simply read MCL 566.132G as prohibiting any type of oral agreement between my client and her doctors. The statute doesn't say that. It doesn't expressly or impliedly in any way amend, annul, nullify, or negate the doctrine of statute of frauds or how it operates with the exceptions, exemptions, and removals from the statute. It would defeat the purpose of the statute of frauds to allow the defendants to escape their obligations after they induced my client to do something she didn't want to do. It would be beyond fraudulent to allow them to escape their obligations under this oral agreement by saying the statute of frauds, no written contract. And so therefore, even though we were dead wrong in inducing you to do something you didn't want to do, you nevertheless have nothing that you can do about it because the statute of frauds will prevent you from enforcing this agreement. Now, this was a contract that related to what to do or not to do about a pregnancy. The human gestation is 9 months. And so just by that fact alone, it's a matter that would have to have been completed within a 1-year period. And in this particular instance, the injection took a matter of minutes and its effects took just a couple of months before the termination of the pregnancy was complete. And so the fact that it was completed and within 1 year removes this matter from the statute of frauds. The fact of the matter is also that my client fully performed under the contract when she acceded to the inducement and allowed this medication to be injected into her body. Her performance was complete. Now, full performance certainly always removes a contract from the statute of frauds, but even part performance will remove it from the statute of frauds. And in this particular instance, whether you consider it part or full performance by both sides, that removes it from the statute of frauds. Now, the defendant's position was completed also within a matter of minutes. And so we have full performance by both sides within less than a year, within less than a few hours. And so therefore the statute of frauds does not preclude it. I would also indicate that the statute of frauds cannot be interposed to defeat an agreement when one party relies to their detriment. In this particular instance, my client relied upon the representations of the defendants to her detriment. Had she gone with her instinct, had the father of her child prevailed in his assertions and requests for more time and for a second opinion, then the mistake in diagnosing an ectopic pregnancy would have been discovered. It certainly was discovered when she left St. John Hospital and went to Beaumont. The very first thing that was found there was that this was a normal intrauterine pregnancy. So my clients, the father of the child, as well as my client, the patient/mother of the child, relied to their detriment on the representations and the inducement of the defendants. The statute of frauds does not preclude enforcement of this particular agreement. I would indicate that in looking at the brief that was submitted on behalf of the appellees, that the court should pay close attention to the fact that they are asking you to affirm rulings that were not made by the lower court and arguments that were never raised in the lower court. They're asking you to affirm things that didn't happen. And I'm not quite sure how they can explain that. But for example, the trial judge never ever addressed in her ruling from the bench and in the subsequent adoption of an order, never addressed the implied contract cause of action that was also alleged in addition to the oral contract. So the implied contract was not something that was ever agreed to. In their brief, the appellees seem to interchange oral agreement with implied contract as if those two are one and the same or synonymous. They are not. An implied contract arises from the circumstances and the conduct of the parties, not from their agreement. In fact, there doesn't even have to be a meeting of the minds to enforce an implied contract. If the court has any questions, I'll respond to them. Otherwise, I'd like to reserve my additional time for rebuttal.
Okay, no, and we're all set.
Thank you very much. I'm not certain whether to find no questions as being a good sign or a bad sign.
All right, Ms. Ginter, go right ahead.
Good morning, Your Honors. Catherine Gossick on behalf of defendants. Ms. Ginter is no longer at our firm, so I'll be handling oral argument.
Thank you.
On her behalf. I want to keep this short and simple. I think the issues are well briefed. I just want to mention that defendants did file concurrence in co-defendant's motion and did include briefing as part of the concurrence. It was not just a one-sentence concurrence. In that briefing, we included cases such as the Stewart case and the Penner case, which co-defendant also brought up. This case is very simple, even aside from the statute of frauds. This is a medical malpractice case through and through. Penner and Stewart make it very clear that the only time you can have an additional breach of contract claim is if there's a special agreement dealing with a specific act or a specific result. There's nothing in this case to indicate that is the case. This is essentially a medical malpractice case. There's nothing different from plaintiff's medical malpractice claims that were settled in this case to differentiate this claim. And on top of that, not only does there have to be a special agreement with the statute of frauds, it has to be in writing. Plaintiff agreed that there is nothing in writing. Here, the general consent form actually says that we do not hold any promises for a specific result or specific treatment. This is essentially a medical malpractice case through and through. Unless the court has any questions, I would like to rest on my brief.
I have a question.
Yeah.
Now that you blurred your background, I'm wondering what that big object to be to your left is.
That is actually a blackout curtain for my 9-month-old. I'm actually in Jamaica right now.
I figured, I was just gonna say you're probably somewhere nice and you don't want us to know that you're somewhere nice.
Yeah, this
I won't ask if you have pants on or any of that stuff.
It's actually a dress, so I am fully prepared. But this oral argument was scheduled when Ms. Ginter was still appellate counsel. And when I took over instead of.
Are you having a good time?
We just got here last night. It was a long travel day with a 9-month-old, but it's beautiful weather here, so can't complain.
Awesome. Well, and I hope you have a wonderful vacation and congratulations. Is it a boy or a girl?
Thank you. A girl.
And what's her name?
Her name's Quinn.
Quinn?
Yes.
Oh, that's a nice name. Now she's made it into YouTube.
Yeah.
Thank you, counsel.
All right. Thank you.
I want to first indicate that there's no authority cited by the defendants, and there's no case law that exists that indicates that a medical malpractice claim is mutually exclusive to this contract claim. In fact, we did have a medical malpractice claim. That portion of the claim was settled, and that's why Dr. Denier is no longer an appellee in this case. There is no mutual exclusivity as between the two. There's no authority for that, and so I think that's a red herring for counsel to raise that.
Well, I took it, just so I'll give you a chance to respond, I took sister counsel's argument on that to say, not that it was mutually exclusive, but unless there's a special contract, that you have to show that there's a special contract, not just that, you're here for treatment. So that's how I understood her argument.
Well, I understand that. I also understand that that was not an issue that was raised in the court below, and it hasn't been preserved for appellate purposes. But notwithstanding that, I would indicate that there was in fact a special agreement here, and that this agreement called for my clients to accept at face value the representations of the defendants based upon their superior training and education in the medical field, and called for their exclusive reliance, my client's exclusive reliance upon that. And I'd also indicate that Mr. Patton, who was the father of the child, would have no other avenue for recovery since he had no medical malpractice claims. There was no malpractice committed with respect to him. I also would indicate to the court that not only was the special agreement argument not raised, but the other arguments in the defendant's appellate brief not raised in the court below. And so in my reply, I set forth all of the various different assertions of fact, as well as arguments that were raised that were not preserved because they weren't brought up in Dr. Denier's motion or his reply, not to even mention that these appellees would not have the benefit of that reply. I believe that covers it. I would indicate to the court that my grandfather arrived from Jamaica on the day after the sinking of the Titanic. and he arrived here in the United States, but that he maintained contact with the family, and I've done the same, and we're at my homeland right now. So
1916, I think.
1914.
14?
Yes.
Okay.
Yes.
Out of Halifax.
Yes, sir.
Okay.
That's an interesting story. Do you still have family there?
I do. And I got to know quite a bit of my family during my many trips there. Most of my relatives that I knew well were a little bit older than me, and they have passed on. The younger relatives that are still there really don't care too much for the gray-haired guy from Detroit. Except that after that terrible storm and damage done to property down there, they managed to find my phone number.
Now they need you.
Funny how relatives, regardless of where they're from, have a way of finding us when they need money.
Right, exactly. Thank you very much.
Thank you. It's a pleasure to have you, counsel.
Thank you. Thank you, Your Honor.
Thank you both. Thank you very much.
Thank you.
Thank you, Your Honors.
You're welcome.
Take care now.
All right, the matter is submitted. Turning now to item number 21. Wright versus Bradley Rosenberg, MD. That's item number 374382.
What a way to end the day with you.
May it please the court, Mark Bendor on behalf of plaintiff appellant. We're here on appeal from a C-10 summary disposition in a case where the trial court said, even though there's clear negligence and even though there's ample evidence that my client underwent physical pain and suffering, as well as mental anguish, the case is nonetheless dismissed. And there were two counts. There was the assault and battery and negligence. My first reaction was to say that with respect to the trial court's finding that having one's scrotum cut without anesthetic wasn't physical injury, under a common meaning of those terms, I was going to suggest taking a survey of all the men in the courtroom, but there aren't too many left, so I'll go on. With respect to assault and battery, as I understand the defendant's argument, it is that the client agreed to a vasectomy with anesthesia, and therefore there can be no assault and battery for doing the procedure without anesthesia. And I think that's simply wrong. First of all, here's an analogy I thought of. I'm selling Kevlar bulletproof vests to a police department. And I say, I'm so proud of this product that I will put one on and let you shoot me in the chest and I'll show you it wouldn't hurt. And then they shoot me without the vest on. I've made a conditional, if you will, consent, but they have exceeded the conditions that are set forth in the written agreement.
But presumably in that hypothetical, the shooters would, I think for you to have a battery, they would have to know, oh, he doesn't have his vest on, let's shoot him. Here, there's no evidence that I've seen in the records to suggest that this was anything other than a negligent act. The nurse or the person who was helping out,
right?
She readily admitted in her deposition, yeah, I made a mistake here. I didn't put in the right, but the doctor thought there's nothing in the record to suggest the doctor didn't think that this was anesthesia. And I don't see the intent you would need for a battery.
2 points. Well, one, I mean, bear in mind that they had gone through this with the prior patient who said that what you have injected into me has not had an anesthetic effect. I feel the pain. Then you have this particular patient with the first injection screaming in pain. And now you have a third injection of the same substance that's already been proven ineffective. So I could put together, I think, an argument that it goes beyond simple negligence, but let's take it a step further. I think the important point is this, and I've tried to address it in my brief, and I'll try to do some more if it helps. In criminal cases, and I think one of them is Johnson, where they say, in contrast to the common law, for a criminal case, you have to have an intent to hurt. In civil cases, what you need is an intent to touch, an intent to do the act. And so if you may well.
Wouldn't the intent to act here be the touching with a needle that doesn't have anesthesia in it?
The touching is the cutting itself. That's the act. Here's perhaps another analogy.
So I think maybe a better analogy than the one you gave was, let's say you have this awesome bulletproof vest and you invite a police officer, take a shot at it, and you have it on, but there's a little hole in it. And the police officer hits that hole. Neither of you knew that there was that hole. Maybe the police officer should have known because the police officer has more experience. I mean, there's just no evidence that I mean, other than, okay, maybe it happened with the patient before, but other than that, so that's all you have with regard to any prior knowledge or intent or anything along.
Well, other than that, I agree with you. We certainly don't think that he went out of his way to not have the accurate anesthetic. Let me perhaps give another example. Two kids are playing around and one is poking the other, okay? Doesn't really plan any hurt, but at the time the kid turns around and gets poked in the eye and loses his sight. For civil purposes, since they intended to do the injurious act, that's actionable, notwithstanding the fact that they didn't intend to injure. It's the intentionality of the contact, which is significant.
I mean, you have this assistant who admitted that she made a mistake. And I think you could say, well, that would be a question of fact on negligence. I mean, the assault and battery just seems like such a higher hill for you to climb. I'm wondering, what am I missing that you're really focusing on that rather than what would seem to be the more natural claim here?
Oh, okay. But the point is, and I think I'm correct on the brief, that if you look for civil liability as contrasted to criminal liability, common law civil liability is the intentional touching. Criminal liability under specific criminal statutes requires the intent to harm. That's the distinction I'm trying to earn. But I think you're correct that even stronger, perhaps, is the negligence. And not only is there evidence of negligence, there was a partial summary disposition that we had proven negligence so convincingly and fully that there wasn't even a jury question on that. But what the judge did is said, despite that, and despite the standard jury instructions, which say, if you find the defendant was negligent, you can recover whatever mental anguish you find and whatever physical pain and suffering you find. And what the judge did when he said, or she said, there's no physical injury, relied upon the DeCourt case. That was the one case that was cited, and that itself was a criminal case. And in that context as well, they say that for a crime, you need physical injury. But again, that's not the case with civil actions, particularly under the common law.
Let me ask a question.
Sure.
Let's say this case was a surgery for a C-section or a root canal.
Okay.
And the anesthesiologist in both situations uses, in the dentist situation, Novocaine correctly.
Okay.
And the anesthesiologist in the C-section, cesarean section, uses, but in both uses the proper medication. Epidural. Yep. And in both cases, though, they underprescribe the sedative to the point where, so it's the right sedative, unlike this case. It's the right sedative, but it's underprescribed, exposing both patients to excruciating pain, which is quickly remedied by, in the epidural, it's increased, in the Novocaine, a second shot. What about that case? Is that a battery?
Well, I'm moving into negligence, but I don't think it would be a battery if they did the proper procedure, the proper way, with the consent of the client patient. The distinction here is.
So why is it not? I want to make sure I understand your battery argument. In my situation, you're saying those wouldn't be batteries because why?
Because the patient had agreed to having the operation with the sedative, and the sedative was actually given. So you have conduct which is consistent with the consent that has been given. Now, there may well be a malpractice cause of action.
But if the consent,
depending on the fact
given is sufficient sedative.
Pardon me?
What if the consent given by the patient was, you can do this procedure with sufficient sedative, and then under Judge Cameron's example, insufficient sedative was given at the outset, but then quickly rectified? Is that still a battery?
It would depend upon the nature of the consent. For example,
I just said it.
I'm sorry.
The consent given is that that the patient will receive sufficient sedative. Would that be a battery under Judge Cameron's examples?
If it is that I will do it if you give me 200 milligrams, sufficient?
The phrase is sufficient sedative.
I guess then you have a question of interpretation, what that really means. But the important point here is that the consent form itself specifically said with some sedative. And we're not quibbling over amount. We're talking about the terms of the consent itself. I hope that it does. Okay. But getting on to the negligence, it may be what the judge said is pain is an injury. Well, semantically, that's true, but it overlooks that there was an actual physical injury. Something that everybody would look at. In the cases they cite and the judge relied upon, there was no injury at all. For example, the Henry case that they relied heavily on involved some Dow Chemical putting something in, I think it was the Tittabawassee River, which never hurt anybody, or at least not these plaintiffs. And they said, we haven't been hurt, but we're afraid that in the future we might be, and we want to recover for the possibility of a future injury. That's a heck of a lot different than this case.
I'm smiling, that was my father's case.
Okay.
He got reversed, I don't know, 5 times by the Supreme Court. But anyway, it's funny when you say it reminded me of my father.
But the important point is that there was no injury at all. And certainly from any reasonable perspective, there was a physical injury. And more,
which was, in this case, the
incision without anesthesia that caused a physical harm and resultant pain and suffering and mental anguish that would not have occurred other than because of the negligence. And that's why you have the standard jury instructions that say, if there is negligence, you can award whatever you determine to be the appropriate award for physical pain and suffering if it exists, and mental anguish.
If this procedure would have been properly performed, the only difference would have been your client would not have experienced pain. The
Well,
cut would still have happened.
There's also mental anguish, but certainly.
You see my point?
Yes. But that's exactly for the jury to say that you suffered more pain than you otherwise would have. And so the incremental additional pain that is attributable solely to the negligence, not to the procedure itself, that pain and suffering is compensable. And likewise, when you get to the question of mental anguish, the only case that the court cited was Daly, which is the bystander or negligent infliction cases. There's no other body of law that says that you can only recover for mental anguish if it's real serious or it's more than other people would have. And for a C-10 motion, we don't even have any showing by them that this was an abnormal reaction. They argue that, but there's no evidence. And in fact, the plaintiff has contemporaneous medical records as well as the opinion of Dr. Shiner. So we can quibble about the extent of it, but on the proposition of law that someone who sustains mental anguish as a result of negligence can only recover if the other side knew that they were going to be particularly harmed, it just doesn't apply to a negligence action. And I haven't been able to find any case that says in an ordinary negligence case, if you sustain mental anguish as a result of that negligence, you can't recover unless they knew or your anguish was beyond some theoretical normality. So at bottom, we're asking the court to reverse the summary disposition, submit it to the jury, and let them decide whether there has been, and if so, the compensation for the compensable elements of damage without the limitations that the trial judge erected.
I don't
Is there any other questions?
As always, excellent briefing.
Yeah, absolutely.
Thank you, Your Honor.
Yeah.
One
Appreciate
of the
that.
best, for sure.
Good afternoon. John Fleming on behalf of the appellees.
Who did you bring with you, counselor? I see you brought somebody with you today.
Oh, it's Mr. Wolfmeyer in the back,
Oh,
my
okay.
partner, who's worked with me on the case, and he's observing today. I'll be arguing.
Okay.
I thought maybe he was gonna critique you and grade you.
Well, I certainly hope not, but yeah, probably will happen anyway. So kind of starting with the fundamental premise of law that before damage, you must suffer a present physical injury. So let's start with the case is not. This case is not about a vasectomy that was consented to and performed and achieved the desired outcome in its goal in that respect. The plaintiff consented to it. The consent form is clear. You're going to have some pain after. You're going to have swelling after. And all of that is what occurred to the plaintiff. This case is about a mistake that was made. Candidly, it was a mistake that the assistant did not appropriately staff the operating suite with the anesthetic. So, you know, when we go back to say, okay, what is
That is a very colorful way of saying I screwed up. The assistant, let me see if I can, the assistant did not properly, what was it? Stock the operating suite. I like that.
Oh, that's fundamentally what occurred here. And so what we really have here is
that is what occurred, but you know, to brother counsel's, as I understand his argument, he's saying that the incision is the physical harm necessary to get around Henry and to get around those lines of cases. And is it your contention that because he would have suffered an incision regardless of whether he had anesthesia or not? That is not a sufficient injury, or what's your response?
Our contention is he consented to and agreed to the incision. The claim of injury results from the lack of anesthesia, not the incision itself. The incision was going to happen, and that was a completely consented to procedure.
What about the fact that he got several shots when presumably if it had been done properly, he would have gotten one shot of the anesthesia.
He received 2 injections, but it was never alleged that the additional anesthesia or the additional shot that really wasn't the anesthesia was somehow, caused him any physical harm. And the reality is
Probably
that
pretty painful.
well, I mean, I'm not doubting that this was a painful experience, but the reality is that the precedence of this court says pain is not injury. Pain is not enough. You need some type of physical manifestation beyond just pain. So what do we have here? Plaintiff presents to Beaumont 2 days after, and we have normal blood pressures. We have an ultrasound that is performed, a Doppler, that says, basically normal postoperative changes consistent with a vasectomy. We don't have any allegation of any economic harm, which Henry says you absolutely need to maintain a negligence claim. We have his complaints that this lack of anesthetic caused me pain. That's the entirety of the injury. And he goes on to say, well, it also caused me some emotional trauma and some emotional harm. But the precedence of this court is that emotional trauma also requires a physical manifestation, and it requires allegations and proving of economic harm. There was none of that in this case. The entire premise is no anesthesia, it hurt me, and now I'm traumatized because of it. And there's just not enough there to tie it to something else. Brother counsel
would pain be enough for the battery charge or battery claim?
Well, I think there's body of law in battery that says that certain areas of damage can be presumed if there's battery. But in this case, and I think your questioning to brother counsel was enlightening on that, the cases, in civil cases, it requires not the intent to touch, it requires the intent to injure. And that was clearly not here. That's completely undisputed. Dr. Rosenberg, the nurse assistant, everyone testified, it's just clearly a mistake. They didn't intend to.
About opposing counsel's argument that if this had been the first instance, okay, maybe, but this was actually the second or third. Like there was a prior patient who also experienced pain, and that should have put a reasonable person on notice of, hey, maybe there's problems with the anesthesia.
Well, the prior patient went through the entire procedure and did not even know that there was lack of anesthesia until he was called after and told by Dr. Rosenberg, because when they realized the mistake occurred, they called him after and said, this incident occurred, and he said, oh yeah, that did kind of hurt more than I was anticipating. And so there wasn't enough causal nexus for Dr. Rosenberg or the assistant to sit back and say, well, we should really check this because that procedure went off without an end.
So the prior patient at the time it was during the procedure didn't complain about extraordinary pain or anything. So it wouldn't have put the doctor or his assistant on notice of, hey, we need to do something different.
That's correct. And I don't want to go outside the record, but we talked to the prior patient and he got home and he told his wife what happened, and she said, shut up, I've given you 3 kids, and this was, nothing. So, that was,
You don't have to go outside the record. I think every guy on that exact
you can take judicial notice of that. And so I kind of want to just a couple of additional points. The jury instructions that the appellant relies heavily on deal with elements of damage, but you don't get to damage unless you have injury. And that's what we don't have in this case. And in terms of the distinction they try to draw through Daly and the kind of eggshell plaintiff theory, he says that there's no evidence that this plaintiff had an abnormal reaction. I think the record is absolutely replete. His writings, his complaints, he's compared the doctor's office to a cocaine cartel and a gulag. He was doing things on the internet and on Reddit that I think no normal person would have the type of reaction that he did. And that wasn't refuted in the trial court. They never argued that this reaction was normal in any type of way. And, so I think that Daly's never been limited to just negligent bystander cases. And the only precedent from the Supreme Court on the eggshell theory is deals with physical conditions, and we cite that case in our brief. It does not deal with the hypersensitive, overly emotional response, which is exactly what occurred in this case. And so we think that that issue is well briefed. And I do want to address one issue because further counsel draws the distinction between civil cases and criminal cases and says we don't have any case that supports it. We do, and we cite it. It's the Means case. It's actually a Sixth Circuit case because it was a diversity case, and we cite it. And the facts are somewhat analogous, but a little bit different. In that case, the patient presents to the hospital and had her water had already broke. She was pregnant. Her membranes had ruptured. And they essentially send her home. And she comes back later and she developed a bacterial infection. And then she later delivered a baby that did not live for very long. And the Sixth Circuit, applying Michigan law, says, Mean alleges, and we do not doubt, that she suffered physical and mental pain, emotional injuries, and quote unquote discomforts and other pain. But these allegations are not sufficient to state an injury under Michigan negligence law. It's interpreting the precedents of this court. It's the same thing. When you have pain, you have emotional trauma, you need something more. If you get into a car accident and the plaintiff has a leg injury, and they go to the emergency room and there's an x-ray performed and they can see a break, they can see a fracture, you've got a physical injury. If they get into a car accident, you say, my leg hurts. It just hurts subjectively. All I'm complaining of is pain. It's not enough. You need more. And Henry goes above and beyond that and says, you actually got to allege economic harm. Plaintiff didn't do that here. There's no allegations he missed any work. There's no allegations that there's any medical bills outstanding. No economic allegations whatsoever. It hurt and it caused me emotional trauma, and it's just not enough under Michigan law. So unless there's any other questions, I'm happy to wrap it up.
It was well briefed.
Thank you.
I'll second.
When counsel says that pain is the ordinary outgrowth of the procedure itself, I think it's important to draw a critical distinction. You have the post-operative swelling, pain, that sort of thing. That is typical, agreed to, etc. The difference here is the intense pain at the time of the operation.
I think we understand that.
Okay.
Yeah, that's
The other, and that's why you have anesthetic in the first place. With regard to the prior patient, I'd have to double check the record. As I recall, the unlicensed nurse or whatever she was, the assistant, said that the other patient had the same condition. I didn't understand her testimony. That could be wrong. I didn't understand her testimony to say we only found that out later. I understood it to be that's what she experienced at the time. But beyond that, I'd ask the court to look at the Holzer case. That's an unpublished recent Court of Appeals case. And what happened there was they had pierced a breast implant, which caused some leakage and replacement and things like that. And they said that the pain was compensable, even though there was no physical injury to the plaintiff herself. It's unpublished, but I urge you to look at it. It's cited in our reply brief because I think it's right on point. Let me address the Means case they rely on.
Well, I would imagine in that case, if you've got a punctured implant, that implant would have to be removed, right? There's a separate surgery that's required.
Correct. But they talked about it was the same sort of argument that because they knew they had, as I recall, the patient had agreed to some procedure which didn't entail piercing the implant. And they were talking about the pain and suffering and mental anguish in that context, which is essentially the same argument. The Means case was a suit in which basically a woman came in, had a condition that probably should have caused a therapeutic abortion, but didn't. There were no other harms. But the defendant in that case was the bishops who had come up with the Catholic rules for running a Catholic hospital that said you can't do an abortion. It wasn't the doctors themselves, as I recall, it was the bishops that they were suing. And that is a much different situation here when the suit is against the people who actually performed the operation and caused the damage. And with that, I will leave it. Always good to be here.
Yep,
Well,
thank you.
good to see you.
Good to see you both. Thank you. Nice job.
I'd give them good marks. Yeah.
We'll have a little discussion.
In addition to the operating suite remark, I also wrote down, it was not his intent. His intent was not to touch and it was not to injure. I thought that was good.
Thank you.
So I'd give him, I'd give him, there's room for improvement. Creativity. Yeah.
More than adequate.
Thank you both. Interesting case. I mean, from a legal standpoint, you certainly feel sorry for anyone who suffers pain, but it's an interesting case.
Thank you very much.
Thank you both very much. All right, turning now to the next case, item number 22, Inouye Road Smith minors. No one is in, I'm sorry. That item number is 376244. All right,
He does it all the time.
The matter is submitted on the briefs. Turning now to the next case, Inouye Williams minor, 375701. We have one party, Hugh Marshall, who is endorsed, but I don't see him in the courtroom, and I do not see that he's endorsed for remote argument. Therefore, that matter is submitted. Next case, Inouye Duggan minor, that's 374155 and 374156. Submitted on the briefs. I do not see anyone is endorsed.
There is one endorsed
Not
judge, but not present.
Yep. And then turning on to the next case, item number 25, Inouye Brown Davis Minion minors, 376359. No one is endorsed. Item number 26, Inouye Santos minor, 376104. No one is endorsed. That matter is submitted on the brief. That concludes argument for today.